Everybody, it's Dave Stouse from Husch Blackwell. I am a partner at the law firm and co-chair of the Privacy and Cybersecurity Practice Group. I'd like to first thank you for joining us today and welcome you to the program. We're going to talk a little privacy law today. Hopefully you're in the right place, in particular the Colorado Privacy Act. Before we begin, just a couple of housekeeping items to make sure I don't get in trouble. One, if you have questions, feel free to ask them. It's kind of tough for us to get through them in the presentation, honestly. But if you've attended prior presentations, you know we try to get back to you with any questions that we feel like we haven't answered through the course of the presentation. I'm told that there is the presentation slides are available if you press something on the bottom of the screen. Obviously, I'm logged in on a different platform than you guys are, so I can't see what you see, but I am told that it is there. If you have questions about CLE, I'm also told that there's a prompt on the bottom of your screen to navigate the CLE process as well. Okay, those are the housekeeping items. Thankfully, we're over with that. I would like to briefly just introduce you to the speakers today. I am the picture on the right there. With me today are Malia Rogers and Shelby Dolan. I think those of you who work with us, this is a familiar crew for you. What I should say is there are QR codes at the bottom there. Those will take you to our LinkedIn profiles. So I encourage you to friend us on LinkedIn. That way, you know, today doesn't feel like just a one-time thing. You can keep on track with all the alerts that we put out on various privacy law issues. Yeah, it's just an interesting way to kind of keep track of us. Okay. Those of you who have attended prior webinars know that I like to start with a roadmap. This gives you guys an idea of where I'm going, maybe it heads off some questions that you have. A couple, you know, threshold issues though, right? Okay. So I worked on this deck, and we worked on this deck, I should say, over the weekend, and it got up to like, I don't know, 75, 80 slides, right? And I thought, oh my gosh, there's just no way we're going to get through this. So it's pared down to about 60 slides now, and it's going to be a challenge now to get through it. And I give all that to you to say there's a lot going on here, as you might imagine, with, you know, just as the California law and the Virginia law and now Colorado, there's a lot going on. So because of that, we're going to talk about a lot, but we may not do the deep dive that on every single issue. But I think it's important to do a survey so you get an understanding of the moving pieces. What I contemplate doing is in August, I'm contemplating doing another webinar. Where actually I'll go through and compare the Virginia, California, and Colorado provisions on various items. We have some of that in here, but a lot of that ended up on the cutting room floor just to be able to fit this into the hour. Also want to kind of give you an update on where things stand right now. The process, you know, this bill was proposed. It underwent substantial revisions in the Business, Labor, and Technology Committee. We logged all of those substantial revisions in a blog post. And then it went to the the Senate floor, and on second reading, the bill went under another substantial revision, and a number of the consumer-friendly provisions were added back into the bill, okay? So I think it's important when you're like looking at literature on the bill and what's in it, that you understand it changed substantially in the process of becoming, you know, passed by the Senate and then the House. So the Senate passes it, it goes to the House adds 7 amendments to it in the Finance Committee, and then tweaks it in the in appropriations as well. I think there were a couple other amendments as well. But the major substantial revisions occurred in the Senate. House passes the bill, goes back to the Senate concurs in the amendments, and now it's on its way to the governor. All indications are the governor is going to sign it. We're just waiting for that to happen. But for reference, the governor actually participated in, and one of the last amendments was an amendment to exclude certain types of state information. So all indications are we're on the rock and roll, and it's just a matter of time. One other bookmark to begin with is, you know, to give you a frame of reference, this law is based on the Washington Privacy Act, which we've been talking about for years now. And, you know, obviously the Virginia law as well was based on the Washington Privacy Act. So this law is, the structure of it is Washington Privacy Act. There are aspects of this law, in particular like the definition of consent, that are drawn from the California Privacy Rights Act, but that's the frame of reference for you guys to sort of think through. Okay, so that's the scope. I've talked long enough about, the roadmap. I've talked long enough about all of that. I'm going to turn it over to Malia to talk scope. Before I do, I just want to bookmark one more thing, which is on the bottom left of a number of our slides here, you're going to see numbers, and those are statutory references. So if you want to say, hey, I want to read more on this topic, you can just take a look at the bill itself and then dive in. Okay, so I'm going to turn it over to Malia to give you an understanding of scope.
All right, thanks, Dave. So yes, jumping in with the most important question, which is who does this apply to? As Dave mentioned, this is going to look familiar to those of you who are familiar with Virginia's law. So Colorado is similarly going to be targeting controllers that are producing products and services that are targeted to Colorado residents. The differences here between how Virginia reads is that Colorado adds a few additional terms. So Colorado states produces or delivers products and services, and then products and services is qualified by the term commercial. They also, in front of targeted, state intentionally. So not sure the weight of all these nuances, but just worth pointing out that it doesn't track exactly as Virginia reads. So that's the first qualifier, and then you need to meet one of two thresholds. You either need to control or process the personal data of 100,000 consumers during a calendar year, or you can meet a lower threshold of controlling or processing the personal data of 25,000 consumers, and you also sell data. So that is going to be a notable difference here with the Colorado law. And so we're going to break down some of the terms that are used in this scope definition. So controller, nothing significant in terms of how the plain language reads. It basically includes any legal entity, but unlike California and Virginia, there is no additional provision that is excluding nonprofits from the scope. So first major notable difference with this Colorado law is that it does apply to nonprofits. One of the more business-friendly aspects, though, that's worth pointing out is if you guys are already complying with California law, you recognize that they have this limit on sharing data with affiliated companies if you don't have co-branding, and that's a significant difference with California. Colorado does not have that. Further, it only requires 25% shared control. So data can more readily flow between affiliated companies. So that is a business-friendly aspect of the Colorado law. Looking at the definition then of consumer, it's your Colorado residents. It is similarly targeted to the B2C data. It does not include employee data or B2B data. And then in terms of hitting those thresholds, the 100,000, or if you're selling data, the 25,000 mark, processing is broadly defined. It also includes storage. So if you, over the calendar year, hit one of those thresholds, you're going to be swept up into this Colorado law. And it's also just important to note that Colorado is growing. Last we checked, we're at about 5.8 million in terms of population. So looking at that 100,000 mark, if you're doing business in Colorado, that means that you're targeting less than 2% of the population. And like I said, we continue to grow. So it won't be hard to trigger this law if you're doing business here. Another notable difference to California is that we don't have the monetary threshold here. California has 3 thresholds, one being if you have annual gross revenues of 25 million. That is not present either in Virginia, and similarly, it's not present here in the Colorado law. So you're really just looking at meeting those consumer thresholds of 100,000. And then another notable difference here is for that lower threshold, if you are selling data and you process or control the personal data of 25,000 Colorado residents, then there's no other requirement, whereas Virginia and California qualify selling by you have to generate 50% or more of your annual revenues from the sale of data. That is not found in Colorado. So if you're doing any sort of selling, and we'll go into that definition more throughout this presentation, it's going to be a really easy threshold to meet if you're processing or controlling at least that 25,000 threshold. And then I just want to pass it over to Shelby, and she's going to discuss whether you're going to be subject as a controller or a processor.
Thanks, Malia. Here is the section that you can look to for determining whether a person is a controller or a processor. This section tracks Virginia's law, except for the two sentences that we have here in blue. Really, in short, if a processor steps outside of its duties or its instructions from the controller, or begins to determine the purpose or means for processing that data, then that processor will actually be viewed as a controller under Colorado's law. What's also interesting about the use of controller or processor is that these, if you're familiar with the GDPR, then you know that controller and processor comes from the EU, and it's a question of should we look to the EDPB's guidance for more information on who's a controller or processor, and so forth.
Back to me, I think. And I saw one question come in. I just want to kind of reaffirm something Malia said on this 100,000 and the 25,000. It ties in, again, not only to the definition of consumer, but also to the definition of process. And so, controls or processes the personal data. And process, again, as Malia said, process includes not only the collection, so it's not just the collection on an annual basis, but also storage, right? And that's significant. And so just to reinforce and answer the question, this aspect of it's not just what you bring in on a daily basis, but it's what's on your servers. Is really significant when trying to figure out that 100,000 or the 25,000, which again is very unique how Colorado is coming about that. Okay, enough of that. Exemptions. This is always a favorite topic for people, which is the am I excluded? There's a lot of exemptions. Point being, you're going to want to spend time with it. It's in the applicability section, 6-1-1304. Similar to Virginia, there is a straight-up GLBA exemption. So if you're a GLBA financial institution, you're exempt, and your data is exempt as well. That is trickled down into this bill. With HIPAA organizations, covered entities, I cannot find a straight-up, if you're a covered entity, you're exemption in this bill. It's in Virginia. I don't see it here. I've looked at it 3 times now. What I'm going to tell you, though, is there's about a page and a half of healthcare-related exemptions, right? So I'm going to give with one hand and take away with the other hand, or vice versa there. And I don't want to leave you with that misimpression. There is a page and a half of healthcare-related exemptions. Whether that gets you to the end game of feeling like you're exempt is I'll leave it to you to determine. But it's there. I just don't see a straight-up entity exemption. Certain data maintained by the state as well. It's something, if you are in that capacity, you're going to want to take a look at that applicability section. This was an amendment that was added in the House. It was one of the final amendments that was added to it, which exempts certain data held by the state. And I say, there is, and I wrote a book on Colorado privacy law, right? I mean, nobody read it, but I wrote a book on Colorado privacy law. It's a cure for insomnia, I think. But there is a structure of privacy that applies to certain types of state entities, right? So, I think that was one of the thought processes there. Certain data maintained by public utilities as well. I know we tend to get a lot of entities in the system, the farm credit system that is, no exemption in place for farm credit associations. I didn't see it. Take a look, but confirm. But I did not see the farm credit exemption like we see now in the CPRA and in Virginia as well. Next slide is certain FCRA data. Again, I mean, sort of like this financial stuff, right? Excluding this. Data maintained for employment records purposes. Again, Malia emphasized, the definition of consumer right, but there's a backup exemption as well there. Air carriers, data subject to the Driver's Privacy Protection Act. and data regulated by CAPA, Children's Online Privacy Protection Act. I think, that kind of comes into play with the way the bill addresses child. If you were as silly as I was to listen to all the committee hearings, you would know that there was actually a half-an-hour debate over the definition of child, which is defined as under 13 in this bill, but they were debating whether to, A, delete the definition entirely and have no definition of child, make it under 16 or make it under 18. It's one of those aspects that I think they're going to come back next year and address it. And I think that's kind of worth saying as well now that I've hit the topic, which is I don't think it's done. I think there's there's a lot of comments in the committee hearing process talking about, hey, get something on the books, come back and tweak it next year, right? So, the effective date is July 1st, 2023. We're going to talk a lot about what that means and what that means for you getting in compliance with it. But I don't think this is a done deal yet. I think we're going to have some tweaking next year at least. Okay, one other really interesting aspect of this bill is how it addresses higher education institutions. So there is a FERPA exemption. FERPA data is that CPA doesn't apply to FERPA data. And then there's this provision that says it doesn't apply to a state institution of higher education. I know there's a lot of higher ed individuals listening, so I want to tease this out just a touch. So it doesn't apply to data maintained by state institution of higher education as defined in this statute. Here's the statute. I'm not going to read it. You would log off and never listen to one of my webinars again if I read this. But there's the statute, and it's in the deck for you. So if you're on here from a university and you got some questions here, take a deep dive offline. Okay, good. So personal data, looks like it's still me on this one. Sorry to report to you guys. Personal data, here's the definition. So let's kind of draw this out, right? If you look at GDPR, this is kind of a similar definition of GDPR. It tracks that sort of, general, anything reasonably linkable to you. Very similar to Virginia as well. Different approach than California, though. California delineates all these things that can be personal information under that statute, and like we've calculated it out. I think there's like 48 or something like that, and it gets to be kind of a mess. CPA out of the Washington Privacy Act approach here, and the GDPR approach just says, you're going to know it when you see it. But listen, and we are, keep on talking about GDPR. That's because, that is the foundational document for this, right? There's no doubt about that. And so we will be looking to, interpretations under GDPR for what's covered. And so, we're going to be having conversations about things, not just like name and social security number, but we're going to talk about things like IP addresses and cookies and those types of things, and whether those are personally identifiable, right? I mean, this is a broad definition. It's not a narrow definition. Okay. And then there are exemptions, though, and the first one here is publicly available information. So the way Colorado comes about this one, if it's found in government records, then it's publicly available. And then this second one, which is really where the rubber meets the road here, is information that a controller has a reasonable basis to believe the consumer has lawfully made available to the general public. So it's important to note that this is the controller's perspective, right, not the consumer's perspective. So if the controller has a reasonable basis to believe it's been made public, then they can treat it as publicly available, right? Some of the other statutes, like CPRA, rather, in Virginia, have another qualifier that says something like, unless the consumer has taken steps to restrict access to this information. So what, you're like, okay, Dave, this is gobbledygook, right? But what am I talking about? You're talking about Facebook, right? You're talking about Facebook, you're talking about LinkedIn, right? The question is, if I go on my LinkedIn profile and I push something out there that says, whatever, right? And somebody grabs that, a data scraper grabs that, or somebody else grabs that, is that publicly available information? And so the law recognizes, yeah, right? And I think that just makes sense. But it has to do with data scraping. It has to really do with those aspects. The identified information, first, I'm going to tell you, I used this little guy with the glasses and the mustache in the last presentation I did. Nobody commented on it. I take extreme offense to that, but I'm back again and perhaps teasing the issue here. De-identified, it borrows very close to the Virginia and the CPRA definition of de-identified here. And it's not going to apply to de-identified data And this is sort of like that FTC sort of take on de-identified data. So if this is relevant to you, certainly worth taking a deep dive here and taking a look at this process of de-identified data. Okay, back to Malia, who is going to talk to you about the consumer rights in this bill.
So nothing really novel here as we keep talking about GDPR and Washington. So these rights, sorry, let me advance the slide. They'll look familiar to you. The right to confirm your data is being processed, to access it, correct inaccuracies. Unlike GDPR, you can't go in and complete your data set. You have the right to delete, and we'll go through exclusions later. Those are not actually explicitly listed under this right, as you might find under California's laws. And then you have this right to data portability. So again, this basically is identical to what we see in Virginia's law. The data portability, one difference there with Virginia is Virginia's law is narrower. That right only applies to data that the consumer provided to the controller. There's no such limitation under the CPA here. And there's also unique differences as it concerns opt-out rights, but otherwise the other listed rights here apply with the exception, or don't apply to pseudonymized data. And unlike California, for those of you complying with CCPA currently, there's no 12-month look-back period. We'll go into methods for receiving requests and responding to requests a little later in this presentation, but in general, there's no 12-month look-back period. And then I'll let Dave kind of tease out all these nuances when it comes to the right to opt out.
Thanks, Malia. Okay, so Malia just told you that we've got these basic rights, right? Correct inaccuracies, access, those types of things. And then like this U.S. approach to this whole thing is the opt-outs, right? With one exception, Chubb's going to talk to you in a second about that. But you got the right to opt out of targeted advertising, sale of information, and then certain types of profiling, right? So let's talk about sale of personal data. Again, we've been saying this now for 3 years now in the context of California. Sale doesn't always mean sale, right? The definition of sale, the devil's in the details, and here it is. It's the exchange of personal data for monetary or other valuable consideration. So it includes, the Colorado bill does include the other valuable consideration phrase, which is the one that really kind of broadens it, right? Not found in Virginia. Nevada just moved in their opt-out bill. They just passed it to broaden theirs as well. So it matches that California way of approaching this. There are exclusions, and the exclusions are important. If you're disclosing it to a processor, it's not a sale, but you're going to have some obligations on a contractual basis, and Shelby's going to talk about that in a second. Obviously, for providing a service, if you're disclosing it to an affiliate, Malia mentioned that earlier. And then number 4, right, disclosure of information the consumer directs the controller to disclose by using the controller to interact with a third party, and goes on. What are we talking about here? I think we're going to also talk about it in the context of the universal control. We're talking about like online targeting, right, those types of things. And that leads into the second concept, which is the opt-out of targeted advertising. New phrase to privacy law in this country that Virginia and the Washington Privacy Act, and the Washington Privacy Act never passed, right? We keep on referring to that, but like it's one of those strange mysteries of life, right, where like Washington didn't pass its bill, but it's become the foundation for other states to do so. And so, this concept of targeted advertising, we need to eventually tease it out vis-a-vis sales and where the lines are and those types of things. But basically, as a definition says, you're talking about online tracking, right? That's really, when you look at what these bills are really trying to focus on, a lot of it is like online tracking. It's not everything, but a lot of it is that. And you're going to have these exclusions as well. So again, I'm not one of those guys who reads every single sentence and word on a slide deck. I think you guys can do it as well as I can. But we put the exemptions there for you to take a look at. Profiling is the last opt-out. I should say too, like this bill, the first two we talked about, sale and target advertising. Malia and I were talking about this last night. It's like everything in this bill, like they group those two together, right? is like the opt-outs and then the way it approaches consent and all those types of things. Those two are grouped together, and there's not a lot of distinctions there. And but profiling is sort of like, I don't know, like the stepchild or something like that. But there's a lot of significance here, and so if you are engaging in this type of profiling, then you're gonna have to allow people to opt out. Now, there's really interesting provisions here because it talks about like financial and lending services, but again, like GLBA financial institutions are excluded. And then it also talks about education, enrollment, and opportunity. And I think that's actually incredibly interesting in the context of that higher education slide that I showed before, and about it's not going to exclude all higher education institutions, at least by its terms, right? So anyway, so those are the three, and we're going to kind of come back on a couple of those in the context of the universal right to opt out. But for the meantime, I am going to give it back to Shelby, who's going to talk about one way in which Colorado certainly goes beyond California.
So the Colorado law added consent to process sensitive data. This type of addition for processing sensitive data is really something that privacy advocates have been pushing for and strengthening within these bills. One difference between the Colorado law and Virginia and the CPRA is that the definition actually doesn't include geolocation. So at least in this one area, Colorado isn't going as far. Also interesting to note is that GDPR's Article 9 does not define sensitive data in the same way. Article 9 includes political opinions, philosophy beliefs, trade union membership, but then it doesn't include citizenship or immigration status or personal data of a known child. And then just one last additional note to the sensitive data kind of definition. This doesn't include any type of financial information. So with your bank account information, credit cards, social security numbers, that is not under this definition of sensitive data. So this is really going to be different than what would trigger a data breach notification law. So as for obtaining consent and the definition of consent, this definition is drawn from the CPRA, and it is also broader than Virginia's definition. What's kind of really interesting under consent is that it doesn't include an agreement with dark patterns, which dark patterns refers to using a website to trick you into doing something. Say you say no to doing something on the website and they actually say yes, really just being deceptive and designing it where the website is doing the opposite of what the user actually wants.
And just before we get to the next slide, just to and turn it back over to Malia, to note on these, right, Shelby said it, this is the CPRA, they're borrowing from CPRA here, but CPRA is borrowing from GDPR, right? This concept of specific informed, right? So what they're talking about here is, at the end of the day, my interpretation of what they're talking about here is you would need individual consent for individual types of actions, right? Now, it's backstopped by the fact that sensitive data is not as defined as broadly as to require all types of consent for everything. But I also think it's one of those terms that people can add to over the years, right? That if this bill is not finished, I wouldn't be surprised, as Shelby noted, the geolocation is not there if they add that in, if they add in some financial information and those types of things. And then, the dark patterns, talk about that in a second, but also, it doesn't include general acceptance of the terms of use. And so just bookmark these things for later. I'm going to talk to you about this universal opt-out, and I just want to bookmark those two things for later. Anyway, enough of me. Let's go to Malia to talk about CPRA's approach to this.
Right, so it's borrowing from the CPRA in terms of the definition of consent, but the CPRA does not similarly require consent to process sensitive data. So this, I think we advanced maybe one too many slides, but this is the definition of sensitive personal information under the CPRA. So it is the broadest there is. It includes basically everything we just saw for Colorado. It adds things like your historical or traditional idea of personal data, which is your financial account information, your social security number. And it also includes the precise geolocation or the content of your email communications. What's different with the CPRA is that there are permitted uses of that information, and for businesses that use sensitive information outside these permitted purposes, you need to provide consumers notice and the opportunity to request that you limit how that information is used. But it's, putting the burden there on the consumer, whereas Colorado is putting the burden on the business to obtain consent before even processing this information. So that is a significant difference between these two bills, or two laws, I should say. And I think this is going back to Dave for controller obligations.
Yeah, thanks. So, all right, so let's jump from consumer rights. Let's talk about, fine, I'm a controller, what do I have to do, right? First step is consumer requests, right? So you're familiar with this from Maria's slide. So how are you going to be able to receive requests? You're going to have to identify the methods in your privacy policy. It's not prescriptive. It's not like the CCPA regs where it says things like, you must do X, Y, and Z. There's no requirement for a toll-free telephone number, but there is this concept of, you can't interact with people online and then tell them that they got to affect their rights through the mail, right? If you're interacting with people in a certain way, then you got to be able to provide for that, affecting those rights in that way. And you can't require a consumer to create an account to effectuate their rights and to submit requests to you. So, broader, right? It's not as prescriptive as CCPA goes. Doesn't say you have to do X, Y, and Z. I mean, I think what you're going to get away with is, email addresses. Although, if you're on it, you're one of our clients, we really like the concept of using web forms because you can collect a lot of information up front and speed up the process. But anyway, I think that's what you're looking at. And you're going to be able to match it up with your CCPA process or even Virginia. So the rights to opt out, talked a lot about this before. Third-party technology, they've got this concept in here, browser settings, those types of things, borrowing again from pre-existing laws on this one. The second note there, I kind of want to pull that one out, clear and conspicuous notices, right? Again, so we're talking about targeted advertising and sales. I said before that, profiling is the ugly stepchild, right? And targeted advertising and sales are like grouped together for a lot of things. And so you've got to have a clear and conspicuous notice in your privacy policy and then readily accessible location outside the privacy notice. And so you're probably writing like the question right now, which is like, well, what does that mean, Dave? And it's not defined, right? Sorry to tell you. Maybe we'll get some regulations on topic. We'll talk about that in a second. What my suspicion is they're looking at California, and in California you have to have that link that says, do not sell my personal information, and then in 2023, do not sell or share my personal information, depending on what you're doing. I think they're kind of looking there and they're saying, well, we don't want to dominate website footers, so you could probably use something like that, right? Something along those lines. I think they're leaving, flexibility here, a practical approach to it. But that aspect, though, that second aspect of like, another location outside the privacy policy, that's not in Virginia, right? And what we've found in our practice is that do not sell option really ends up being like the driver for consumer requests, right? So I expect that to the extent you're selling information or targeted advertising, that's going to be a big deal. The way that they're approaching this and requiring you to have a separate notice outside of it. Another way in which Colorado is stronger than Virginia is this universal opt-out mechanism. So here's how it's going to work. July 1st, 2024, so the bill is going to go into effect July 2023, although there's lots to be done before then. But in a year later, controllers are going to have to allow consumers to opt out using a user-selected universal opt-out mechanism. That's a mouthful. What's the concept here, right? The concept here is, should a consumer be able to take one step, i.e., use a universal opt-out mechanism, or should a consumer be able to, across all websites that it goes to, or should it be required to go to every single website, click a button, and like do a do not sell request, right? And so privacy advocates have looked at this and they've said, if a consumer doesn't want to be tracked, they shouldn't be tracked. And you shouldn't require them to go to like 20 websites a day and opt out of tracking, right? It's too much. And so that's the concept here, is this universal opt-out mechanism. Now, the AG's office has to issue technical specification. It's one of the regulations they're going to have to promulgate. And I said before, if you recall, a few minutes ago, I said, you know, let's bookmark this concept of consent, right? And we were looking at the definition with Shelby. One way in which, well, the way in which you can get around the universal opt-out mechanism is consent, right? And so, you know, somebody has said, I don't want to be tracked. They can show up on your website. You can direct them to a web page, app, or something similar that would obtain their consent for the sale or targeted advertising, right? But consent, again, has, you know, it can't be a dark pattern, right? And so what does that mean? As Shelby told you, that means like you show up on a website, you think you're clicking yes, but in fact you're clicking no, or like the coloring on one button is brighter than the coloring on the other button, or like you think the only way to accept cookies is clicking accept, but like even the dismiss button, the X button still sets cookies, those types of things, right? Like the law has caught up to dark patterns, point being. So anyway, this all kind of bleeds into this concept of like tracking you across the internet, right? And then everybody's going to be sitting there and going to be telling me like, well, yeah, but I've read articles saying cookies are gone, right? And Flow C is going to replace cookies. Yeah, we're cognizant of that. We'll see where it all ends up, right? We're going to see where it all ends up. Consumer request then is, you know, similar structures in Virginia. You have 45 days to respond to a consumer request. You can extend it for 45 days. You do have to authenticate the request, but it's squishy as to authentication. It's not like the CCPA where it's got all regs lined up, right, for that. Free of charge unless it's a second or subsequent request within a 12-month period. That's better for businesses, you know, repeat requests and things like that. If you decline a request, you know, given the go pound sand response, then you've got to tell them within the 45 days, and then you've got to provide an appeal procedure, which is a unique aspect of the Washington privacy line of statutes. It's not in the CCPA, CPRA line of statutes. And so you know, you have to have this appeal procedure, and then you've got to be able to process the appeal, and then if you deny it, you've got to give them the contact information for the Attorney General's office, right? It's like, to contact the Attorney General's office about your denial, please click here, those types of things, right? So not incredibly business friendly there, but it is what it is. Okay, so let's talk about, you know, in this context of controller obligations, privacy policies, and I will turn it back over to Shelby.
Yeah, so under Colorado's law, controllers have the responsibility to provide a privacy policy. Now this responsibility is only for controllers. It is not for processors. And some of those obligations under the privacy policy disclosures is pretty common across all three laws. You need to consider disclosing the type of data you're collecting, why you're processing data, who are you going to share that data with, are you selling that data? Like I said, that's pretty consistent across Virginia, California, and now Colorado. There is no requirement for an employee privacy notice like there is under the CCPA and the CPRA, but this makes sense because employee data doesn't fall under the definition of personal data under Colorado's law. Most important, an important note to make is that a privacy policy really needs to be clear and meaningful, which, you know, the more laws we get on the books, this is going to become a little more difficult to do. You have to think, how are we going to draft just one privacy policy, maybe covering all of these different laws, while still keeping it very transparent for users? That will probably get a little more difficult when we're trying to include so much information. So that's important to consider.
I think we're going to flip it over to Malia to talk about data protection assessments.
Yep, so this is something you'll see in Virginia, et cetera. But basically, Colorado is requiring that anytime the processing presents a heightened risk of harm to the consumer, you need to conduct and document a data protection assessment. And this will be important because the AG's office or district attorneys can request access to these DPAs, so they need to be documented. Examples of what would be a heightened risk of harm are 1 through 4. So if you're doing targeted advertising, selling data, processing sensitive data, and then certain types of profiling, those all those activities are going to require DPAs. and I shouldn't say DPAs because we're going to talk about agreements in a second, but you're going to have to do these assessments. And then in a note there, you can see at the bottom some of the caveats in terms of when profiling is going to require you to do one of these assessments. Good news is that it's not going to be retroactive, so this is all going to apply come July 1st, 2023 to activities that begin on or after that date. But essentially it involves weighing the benefits, the risks, your mitigation efforts in terms of those risks, aspects of whether the personal data is de-identified will come into play. And as I mentioned before, this is going to be a requirement in 2023 under the CPRA for California, but more is going to come out over the next year with the rulemaking process. So getting a handle of what's going to be required under these and how they're going to be documented, hopefully this can be something you can align for both California and Colorado. And then most importantly is here within the statute, it specifically states that if these are done under attorney-client privilege, if and when an attorney general or DA requests access to them, that privilege will not be waived. So the main takeaway here is conduct those assessments under attorney guidance so that you maintain that privilege moving forward. And now I believe Shelby will walk us through DPAs, so the data processing agreements.
Yeah, so data processing agreements, like Malia said, DPAs. The Colorado law provides about 10 requirements that need to be featured in a DPA you have between your controllers and your processors. I'm not going to read all of this information, but we really like to think of these requirements kind of as a baseline to your DPA. It's really important, especially as more laws get on the books and more jurisdictions are involved, to think about how you are drafting these agreements so that they're advantageous to the party you're representing. Not just providing 1 through 10, but also looking at providing your limitation of liabilities, indemnification clauses, warranties, and making sure that really helps the party you are representing, especially when it's concerning your security incidents, your security breaches, really having those provisions in place to protect your client.
I think we're going next to other controller duties, but I think just to take off what Shelby was just saying there, right, I think one of the challenges as well, understand in the context, right, is, you know, California is going to have requirements on data processing agreement. Virginia has requirements on data processing agreements. If you're in Europe, I mean, let's not get started, right? That's a whole other webinar on Europe right now. But you've only got one contract, right? And so you've got to get this all into one DPA in a way that makes sense, that protects you, that navigates the various issues here. So this is something we're going to be focusing a lot on. And, you know, we'll talk about it later with the takeaways, but it's a big project. It's a big project to identify all your processing activities and to button those up with processing. And there's also existing statutes in Colorado that you have to consider as well. Okay, other controller duties, 1 through 5 here. It's kind of interesting. They throw in a number of different things in the bill. And some of these change along the drafting process, but purpose specification, again, you got to tell them what you're, you know, why you're collecting it. Data minimization, they actually had an aspect in the bill originally that went far further here. It was actually going to, you know, require to get rid of information specific time period. But here's this concept of like you're only going to keep it for as long as you need to keep it, right? So no hard and fast rule here, but again, it fits into this like you can't lose what you don't have type concept. And then consent is required on the duty to avoid secondary use. So that's the third time consent's come up, right? So if you've basically collected information telling people, hey, I'm gonna use your information for X, and then you start using it for Y, you got to get their consent to do that. So, you know, it kind of depends on how those kind of issues pop up, but think about that, right, in the context of making sure your privacy policy disclosures are broad enough to be able to encapsulate what your marketing department may come to you next year and want to do, right? You don't want to get in a situation of saying, well, yeah, well, we only collected these emails under the concept of subscribe to our blog, and now you're telling me that you want to push out these emails, for other things to these email addresses, right? Is that consistent? Is that a secondary use? Things to think about. Duty of care, make sure that stuff doesn't get breached, but that exists already in Colorado law. We'll talk about that in a second. And the duty to avoid unlawful discrimination, that's in California. It's pretty consistent, right? And frankly, it says you shouldn't process data in violation of federal and state laws. I don't know why they needed to reiterate that. It seems like the federal and state laws will handle that. All right, back to Shelby, who's going to go through processor duties briefly.
Yeah, so the processor duties are a little less extensive. So you need to assist your controller with consumer requests, look to help your controller again with any information security and breach notification requirements, and providing any necessary information to controllers in order to conduct those data protection assessments that Malia was touching on. These are just basic duties you're going to see with processors when you're drafting your DPAs. I think it's important to clearly lay all of these duties out in your DPA, especially when you are drafting a DPA on behalf of the controller. Make sure that the processor is following all of those duties under Colorado's law.
So pivoting now to limitations. So just to kind of place this in context, right, at the beginning we talked about exemptions. So this is sort of a derivative of that, right, with respect to limitations. So I've got 3 slides here. There's a few more in the statute, but we teased out the ones I thought would be most relevant to our listeners. So the law doesn't restrict your ability to comply with law. It's always good news. It means you don't have to not comply with law. And these other ones that you would expect, right? You can cooperate with law enforcement. You can use information to pursue or defend legal claims. You can provide the product or service. You can perform a contract with the consumer. It's very consistent with the approach in this country, California, Virginia, with how these limitations, play out here. Fulfill a warranty is also one, right? That's always the question of like, okay, you want to delete your data, but I have a warranty with you, right? Or you have a warranty with me, I should say. So, like, what happens to the warranty, right? You could say, deny the request on that basis, that you have a warranty with us. Then the protect vital interests of the consumer or another individual. That kind of is this concept of, guy is, in terrible health trouble, and the CPA requires consent for the processing of personal information and medical information, and in theory you're outside HIPAA and all those other exemptions. Like, you have to basically be like, I'm sorry, I can't help you until you consent, right? That's not the way we want to really approach privacy laws. We don't want to get in the way of basic common sense. So that's kind of the idea here. Prevent security incidents and fraud. Again, important exemptions there, right? It's not going to prevent you from investigating that security incident, that data breach, when you're having a look and say, like, what information is impacted, or maybe using data in other types of use cases. And engage in certain types of research if that's relevant to you, then take a look at it. And then, just kind of rounding out the third slide on this topic, public interest in the area of public health. It's kind of got like COVID shades to it, right? We don't want to let these laws get in the way of stopping pandemics and the like. Product recalls, identify repair technical errors, and then this last one is sort of burying the lead, right? Perform internal operations reasonably aligned with consumer expectations. Well, that could be a lot, right? But what's probably worth noting is at the end of the limitations provision here, I haven't put it on the slide, but it says, okay, if you want to use a limit, the burden's on you, right? So let's just kind of think about how this would play out. This would play out where somebody comes to you and they're going to say, delete my data. And you're going to say, no, I'm not going to delete your data because I am performing internal operations reasonably aligned with your expectations. And they're going to say, no, you're not. And you're going to say, okay, well, here's my appeal procedure. and they're going to appeal, and then you're going to say, yep, still performing internal operations, we deny it. And then here's the information for the Attorney General's office in case you'd like to lodge a complaint, right? So, and the AG's office would say, well, this is all very interesting, but you have the burden of proof on this issue, business. So I think that's kind of like the backstop there, right, on this sort of catch-all phrase. Okay, enough of that. Enforcement is probably also kind of burying the lead in some respects, right? What happens to me if I don't comply? So it will be enforced by the Attorney General's office and the district attorneys as well. That is pre-existing, right? So this statute is important to note. I don't know if I've pointed this out yet, but this statute fits into the larger construct of the Colorado Consumer Protection Act as distinguished from privacy, right? But within the Consumer Protection Act, there are many different statutes, such as like the Data Breach Notification Statute, the Information Security Statute, but also things like, consumer protection, right? Like, I think there's something in there about like bath salts or something along those lines, right? But those are like the consumer fraud type issues of like, hey, you can't have that going out of business sign in your window for 6 years, right? Like, that's consumer fraud. So it fits into that structure, which has already been enforceable by the district attorneys, right? I mean, there is AG and district attorneys. Now, our district attorney is going to jump in and start doing privacy law enforcement. I mean, I'm not going to try to sell you that bill of goods, right? But it's there. It's worth noting. There is no private right of action. Is also worth noting. That has always been a big deal. The right to cure is incredibly interesting. It needs discussion. So you will have the right as a business in the first, year. It sunsets January 1st, 2025. I think I had that right. Now I'm kind of wondering if that's July 1st, 2025. But is it okay? All right, it may be July. So sorry, I'm going to have to go back on that one. It's going to sunset. I thought it was 2 straight years, but I'll have to look back at the statute. The point being, though, is the right to cure is going to sunset, right? You're going to have the right to cure, which is essentially the AG's office will send you a letter saying, hey, guys, you're screwing it all up, right? And you would be able to say, okay, we're going to fix it. And you have to do that within 60 days is the concept. But that's going to go away, and that's intentional, right? And the intentional is, hey, listen, we want our businesses to comply with this law. We don't want to create a statutory structure where everybody basically waits for the letter and then they comply with the law, right? And so, but Weiser and Attorney General Weiser, who supported this bill, went on an IEPP webinar and talked about this right to cure. And one of the concepts that they came up with, and they were talking about in that webinar, was, well, what if you sunsetted it? What if you made the right to cure to go away after a certain period of time? And lo and behold, 2 weeks later, that concept ends up in the Colorado Privacy Act. Now, it will be replaced, as we'll talk about in the next slide or one of the next ones, it will be replaced by the option of having to go to the AG's office and asking questions from the Attorney General's office about how do I comply with this law, right? So that opinion letter process, which also was something that Weiser talked about on the IIPP webinar, and is also something that ended up in the law, right? So essentially, he went on an IIPP webinar and said, I'm thinking about these things, and lo and behold, a couple weeks later, it all ended up in the law. Damages, finally. 20 grand. Higher than the CCPA, statutory damages. And it has some language. You should take a look. It has language in there that talks about, per consumer, per transaction, right? So there's a multiplier there. And there's, back and forth, I understand, about like how that multiplier would be applied. But this is not, in my mind, a concept like, hey, I don't have a privacy policy, it's a 20 grand thing. I think this is, I don't have a privacy policy and it's 20 grand times something, right? Or maybe it's less than 20 grand. I mean, they can go after you for less, right? There used to be a cap. There used to be a cap on this, and in 2019, they got rid of the cap. It was 500 grand, and they got rid of the cap. So anyway, I think point being, right, is there's some real damages here. There's some real enforcement. It all comes back to the idea of, like, how much can the Attorney General's office enforce this, right, the resources and those types of things, and full admission on that one, right? That's what it comes down to. What I should say, though, is, we have an active Colorado Attorney General in this space. Make no doubt about it. Okay, rulemaking, is this still me? Hard to believe. Okay, I talked a little bit about this before in other slides. So general rulemaking, the AG's office can promulgate rules. There's no requirement. This is not CCPA, CPRA, where it says you have to promulgate rules on these topics, except that universal opt-out mechanism, yes, that's going to have to be put in place July 1st. The AG's office is going to have to be publishing those, and again, that goes into effect 2024. And then there's that opinion letter process I talked about before, right? Trying to bridge that gap between like, hey, and the concept again is we want to encourage businesses to comply. We want to provide the resources for businesses to comply. We want to tell them things. We don't want to be like California is right now where they're not saying anything. They're just like enforcing it and everything's confidential. They want to be open about this. But the flip side is if they're telling you stuff, you better do it, right? That's the flip side. Okay. Effective date, I think, Shelby, I think you're back up.
Yeah, so the effective date for Colorado's law is very similar to the CPRA and Virginia's law as well. It's going to be July 1st, 2023. Virginia is going to be January 1, 2023. And then the CPRA is going to be fully operated January 1, 2023. And then the enforcement date is July 1, 2023. So all three of these laws are going to hit around similar times. This act applies to conduct that's occurring on or after the effective date of July 1st, 2023. And it's probably not a bad idea to get started on compliance efforts for this law and get moving before that effective date hits.
Yeah, and on that point, right, compliance strategy. So let me tell you what you shouldn't do, right? You shouldn't calendar, okay, you know, January 1st, or July 1st, 2023, you know, look at this law, right? If you do, you know, we've gone through this with clients on GDPR, we've gone through this with clients on California, and this is a heavy lift. I'm not gonna tell you otherwise. This applies to you with the data protection agreements, with the data protection assessments, with the privacy policy, with knowing your data, all those types of things. There's a lot of work to be done here, right? And so here's 5 ways to get started, though, right? Is one, you know, judge applicability, and does it apply to you? Obviously, does it apply to all your data? Clear threshold issues, right? And if it's relevant to your operations, does it apply? Does California and Virginia apply to you? And I have to say, it's important to keep in mind, this is the start of privacy law in this country. This is not the end of privacy law in this country. Next year, we will get other states who will pass legislation, right? I'd be shocked if we didn't. And, you know, I think they're going to take Colorado's bill, and I think they're going to try to pass it, improve upon it, those types of things. And so I think what you're looking at is like, you know, understand that this is a process you're going to have to go to, and now is the time to get started. Data inventory, know your data. I said that before. Your online privacy policy, I mean, if you haven't been touched by California or GDPR and your privacy policy is not updated, well, that's an easy one to take care of, right? I mean, it seems strange to me that we would wait until July 1st, 2023, and then we would have a privacy policy that goes up that talks about all of the usage and those types of things. I think, you know, getting that house in order, there's no reason you can't get that in-house in order today as opposed to later. It's something you can take off of your to-do list. Data processing agreements, you got to draft them and you got to negotiate them. You got to identify your transfers, draft the agreements, and then negotiate the agreements. And that is something that, you know, even today is difficult for clients to get their arms wrapped around. And if you are subject to GDPR, then you've got 18 months to get that done anyway with the new SECs. And then, you know, Malia talked about the data protection assessments. You know, again, you got to know your data to be able to know whether you're selling or target advertising, profiling, those types of things. But how can you even get to the point of doing data protection assessments until you actually know your data and know your processing? This is all stuff that takes months to accomplish. It takes years to accomplish, right? So again, and I think if you're looking at it, you're subject to California, understand in California, the final regs on the CPRA, it's a year from now, right? That's when the final reg is going to come out, and then we're going to start driving enforcement. So these laws are in the future, there's no doubt about it, but there's a lot to be done in the present. And then just sort of at the end, I don't want you to forget this because it also kind of blends into what I was just saying, which is we have existing privacy statutes in Colorado. We have the data breach notification statute. We have our records retention statute. We have our information security statute, right? And what I tell you, they're all enforceable by the Attorney General's office, right? And so if you don't have your, you know, if you get a data breach, my suspicion is if you get a data breach starting in 2023, they're going to ask you about CPA type stuff. That's my suspicion. I don't know, and predicting the future. Right now, if you have a data breach, they ask you about your information security stuff as part of that, right? So you got to understand there's a larger context here of other statutes. Okay, so you know we've sort of reached the end of our time here. I want to be respectful of everyone's time. We've hit the hour. What I will do is what I also call my shameless plug portion of the webinar, which is we have a blog. you should subscribe. If you're new to us, you should subscribe to the blog. You should track us. And then I'll also tell you is, next week on the blog, we're going to be releasing a podcast. We've been interviewing lawmakers across the country who are, were gracious enough to come talk to us for a little bit here and kind of talk about their approach to privacy law. And, what I was talking about before about, this is just a start, and it's going to be a fascinating series. And just rounding it out, if you want to, we have previous webinars on Virginia in particular. You can take a look there. That's there. And you can follow us on LinkedIn as well. Okay, big finish. Thank you for attending. On behalf of Shelby and Malia, I'd like to say thank you for attending our webinar. We are 30 seconds over, so I'm going to let you guys go. But I hope you continue to track us on our blog and our other webinars, and thank you again for attending.